SJC-13149, Regan, Stempniewicz, Barbetti, E. Edward Stempniewicz.
Okay, Attorney Tanner.
Good morning, Your Honor. Mark Tanner of Bacon Wilson on behalf of Edward Stempniewicz. This case arises from the grant of summary judgment at the trial court level on two separate and distinct issues. First, the trial court granted the plaintiffs in the underlying case summary judgment on the issue of the formation of a trust by Lubov Stempniewicz. Second, after having made that decision, the trial court then awarded the assets that had been contributed to the Lubov Trust to the estate by way of a constructive trust. The third issue, which is before the court today, is whether the trial court acted properly in granting a separate and final judgment relative to the previous.
Mr. Tanner, could we start with number 3, though, because it's a threshold issue. And I understand that there's thin analysis in the sense that the judge just adopted the arguments in the plaintiff's brief. But here, we do have a novel issue of public significance dealing with an agent or through a power of attorney, the creation of a trust by somebody other than the settled. And even though that issue could possibly be mooted by some of the other claims, when you look at Long versus Wickett, isn't that enough considering the enormous discretion judges have under 54B?
I'll agree that the trial court judges have enormous discretion under Rule 54, Your Honor. But if you look at Long very clearly and very plainly requires the trial court conduct an analysis to enable our appellate courts to determine whether or not there was an abuse of discretion. And I'd suggest to you that analysis is wholly void in the decision of the trial court.
Well, but we need to recognize that sometimes judges do what happened here. What the judge did was said, no, it's not that I'm not doing an analysis. I'm adopting everything in the plaintiff's brief as my analysis. Is that not permissible?
That is permissible, Your Honor. But if you then go back and you look at the plaintiff's brief, the plaintiffs don't discuss Long. They don't discuss the Long factors. They don't conduct any type of analysis whatsoever. And so what that does is it leaves this court to guess the reasons and the rationale for why the trial court acted. And I'd suggest to you that on the rulings in Long, that's an abuse of discretion. With that issue out of the way, the issue that I'd like to address first is this issue as to the apportionment of the trust's assets. It's an issue that's very important in the case, and it's an issue that's very important to my client. In the plaintiff's motion for summary judgment, they don't really raise this issue at all. They don't argue the issue. They don't raise the issue by way of something in the statement of material facts. They simply, as a request for relief, ask that the court grant a constructive trust of the estate's assets, which the trial court then does, skipping the whole analysis of, well, how did those assets get into the estate? Understanding that this issue was at least raised in the plaintiff's motion for summary judgment, Edward, in his affidavit and in his opposition to the plaintiff's motion for summary judgment, makes a very clear and concise statement. The assets.
I'm not sure the order in which you're taking this particular argument. It seems that we have one that should happen first, but nonetheless, their position is that your client said just the opposite many times, and that this one statement in one affidavit is not enough to create a genuine issue of material fact as to whose assets were in the trust.
So if you look at the statements that Edward actually makes, and I believe they're in the record appendix at 49 and 243, what those statements very clearly say is that my mother knew and understood that her assets would be transferred into the trust. They make no mention of joint assets. They make no mention of Edward's assets. They clearly and equivocally on their face don't contradict the statement that Edward makes in his affidavit in opposition to the plaintiff's motion for summary judgment. The only place that this really gets argued at all by the plaintiffs in this case is in a footnote to their reply memorandum to Edward's opposition to their motion for summary judgment, which is where they raise that argument, Your Honor. I'd also just direct you so that I can move on to the next argument, to the motion for reconsideration that Edward filed in this case. And if you look at that and you look at the documents attached to that, it's very clear that the accounts that were used to fund the trust in the first instance were joint accounts. We give you the cover pages for those statements. And so on the record that was before the trial court, accepting the evidence in the light most favorable to Edward, the evidence that was before the judge was that the trust was funded with Edward's money, his mother's money, and joint money. And therefore, when the trial court held that the trust was void from the beginning, you then have to go through and determine as a matter of fact who actually contributed those assets.
But be that as it may, it doesn't matter if through a power of attorney, this Edward, purported agent, cannot create the trust.
Well, I think the issues are distinct. Assuming that you find that Edward didn't have the power to create the trust through the power of attorney, and the trust never existed, which is what the trial court found.
Then you'll litigate, you're saying how much money each put in.
Exactly, and the court skipped that and awarded it all to the estate. And I'd suggest to you that that at a minimum should be remanded to the trial court for further hearings. Moving to the issue of whether or not you can delegate the intent to create a trust, the Uniform Trust Code in Massachusetts is absolutely silent on that issue. And what this does is in effect raises two separate sub-issues: whether or not the trust could be created on the facts of this case, and whether in general it's permissible to delegate the intent to create a trust. On the facts that were before the trial court in this case, the record was that in 2017, Edward had a conversation with his mother, and they talked about things that they might do in order to avoid the probate process. Accepting Edward's representations as true, as you have to for Rule 56 purposes, the substance of the conversation was, let's figure out what we can do to avoid probate. Lubov then instructed Edward to contact a lawyer to figure out whether or not they could create a trust and how much that would cost. Lubov reported back, or Edward reported back to Lubov, indicating the amount and what would happen. Lubov made a determination that it was too expensive, and thereafter directed Edward to go online, as they had done with the power of attorney in a previous will, and see if there was a document that might work. Edward did that.
Along those lines, I don't understand how you say, Mr. Tanner, that the Mass Uniform Trust Code is silent on that issue. First of all, in sections 401 and 402, as it relates to how to create a trust, doing it through a power of attorney certainly isn't listed, or having an agent do it isn't listed. But then, interestingly and important enough, when it comes to 602 and you're dealing with other issues such as revocation, amendment, or distribution, then you have clearly what is required and when, through a power of attorney, you'd be able to be authorized to do this. And you also have some tough commentary in the Mass Uniform Trust ad hoc committee of the legislature, talking about the importance of the creation of the trust, not just being in the power of attorney, but also in the trust document. So I'm a little, I'm not sure I agree with you that the statute is silent on this issue.
Well, the statute is silent with regard to the creation of the trust, not necessarily with changing, alter, or amending an existing trust. Clearly, 602E deals with that issue. And in fact, if you look at the commentary to 602E at the Uniform Probate Code level, what that talks about is the fact that people very frequently use trusts as will alternatives as a way of avoiding probate. And therefore, where you have an existing trust, which expresses an existing, which clearly reflects the settlor's intent as to what assets should go into the trust, who the beneficiaries of the trust should be, what the language of the trust to be. In that circumstances, when you're dealing with an existing trust, there's a very good reason that you would want to have the express grant of authority in order for some outsider to come in and change the trust, which the settlor very clearly and consciously decided to make. That's not the case when you create a new trust. And just circling back to the 2017 discussion that Lubov had with his mother and the facts of this case, in that instance, Lubov, on the record on summary judgment, instructed Edward to create the trust, formed an intent to create the trust, and thereafter told Edward to take the trust to the bank and sign it on her behalf because she had arthritis at that time and couldn't sign. There's no requirement, there's at least no case law that I could find that says she can't tell Edward that he has the ability to sign the trust on her behalf. Now, if you move to the second issue, which is the issue we were just discussing, that being whether or not you can delegate the intent to create a trust, I think it's important to note that at the point that Massachusetts adopts the UPC, there are several other states, I'm sorry, the UTC, there are several other states which have analyzed and addressed this issue, that being Vermont, Oregon, Virginia, and Missouri. And where the legislatures in those states made a conscious decision that you should have an express statement in order to delegate the intent to form a trust, they added that to their UPC or to their UTC. Massachusetts didn't do that. Massachusetts recognized that 602E deals with this will substitute theory, and therefore, in order to change the express intent that's already established, you should have to have an express intent. I'd suggest to you again that if you look at this notion of delegated intent in the context of the power of attorney in this case, it becomes pretty clear, at least in my mind, that you don't or shouldn't require an express grant of authority. So if you look at the POA, or the power of attorney that Lubov gave Edward, which is at page 53 of the record appendix, it gives him broad and almost complete authority over her assets. It gives him the power to do anything he could do through an agent for her stocks, her bankings, business operations, insurance, retirement plans, including changing beneficiaries. And significantly, it gives him the ability to give gifts of all her assets to almost anyone that he wanted to. If you step back and think about trusts in the context of a power of attorney, a trust is really just a vehicle to accomplish some other power which is expressly granted in the power of attorney. And so it's not an end in and of itself, like a deed, for example, would be. So if you look at that in the context of the gifting provision and the power of attorney at issue in this case, Lubov gives Edward the ability to make broad gifts of her assets. If you think about it from 10 feet away from the argument that we've been having, there's really no good reason. And if you look at the cases from the other states, none of them express a good reason for taking away the ability of Edward to do that through a trust as opposed to a direct gift. If you look at our common law and you look at McQuaid and those sorts of cases, what they essentially say is you have to construe the power of attorney to ascertain the intent of the grantor, and you can't construe it to destroy the powers that are granted therein. And so if Lubov gives Edward, right, the ability to give away her assets, there's really no good reason that he can't give the assets to a trust and have the trusts give away the assets. If you were to, for example, come down with a decision that says, in order to create a trust through a power of attorney, there has to be an express delegation of that power. And someone, for example, put in their trust, Mark Tanner may create a trust on my behalf. That language in and of itself, Mark Tanner may create a trust, doesn't have a whole lot of meaning. It doesn't tell you whether you can give away my assets through a trust. It doesn't tell you whether you can do tax avoidance through my trust. It doesn't tell me whether you can own real estate through a trust. All that it does is it says that Mark Tanner may create a trust. You would have to do what our common law already tells you to do, is go back and look at the powers that are expressly granted in the power of attorney and determine whether or not the attorney, in fact, was given that ability, right? For example, the gifting ability. And if they're given the gifting ability, there's really no sound public policy reason why they shouldn't be able to do that through a trust.
This is a legislative interpretation case. And in the commentary, again, to 602, I'm just even putting aside that 602 lays out the process for revocation and distribution, and 401 doesn't even mention power of attorney for creation. But putting that aside for a moment, the commentary of the ad hoc committee of the legislature said that when a settler's power with respect to revocation, amendment, or distribution of a trust, for it to be properly exercised, an agent under a power of an attorney not only has to have that authorization in the power of attorney document, but also in the trust document. So, and we're dealing, again, you keep on mentioning public policy, and I hear you, but this is a legislative interpretation case.
And I think that that's a very interesting point, because if you look at the model language of the UPC, that same where Massachusetts uses the word "and" with regard to the power of attorney and the trust, the UPC uses the word "or." It has to be in one or the other of those two documents. And I'd suggest to you that when it comes to creating a new trust, there's a distinction between creating a new trust and changing, altering, or amending a settlor's intent that they've already clearly expressed in an existing trust. And that's why in that language in 602E in the commentary, they require that that be through an express grant. Otherwise, the use of a trust is just a vehicle to accomplish some other objective. I see that my time is up. If there are no other questions, I'll rest on our brief, particularly with regard to the first two issues that we discussed. Thank you.
Thank you. Attorney Stafford. You're on mute.
Thank you, Your Honors. May it please the court, Angelina Stafford on behalf of the plaintiffs, Regan Stempniewicz, Ryan Stempniewicz, and the estate of Lubov Stempniewicz. I'll address the orders briefly in the order that they're raised in our briefs, first addressing the question as to whether this was a proper 54B certification. Ultimately, the court issued the requisite findings that there is no just reason for delay, and they did incorporate by reference the reasoning and rationale set forth in the estate's moving papers. Those moving papers consisted of the initial motion as well as a supplemental brief. This is an issue that was thoroughly briefed by the parties on more than one occasion and argued on more than one occasion. And those documents on the estate's moving papers are located in 165 through 170 and 176 through 185 on the record appendix. They very clearly address each of the factors set forth in Long, noting that this is a unique question of law that has impacts extending far beyond the parties in this case, that it is easily severed from the remaining claims because it involves the interpretation of a statute in conjunction with a power of attorney based on its four corners, and that it will simplify and expedite other claims, particularly those that may have been raised in the alternative, which need not be pursued if judgment is affirmed, and also alleviates the issue of hardship from a delay with the estate being insolvent and those cash assets remaining under Edward's control. The estate has no ability to pay its expenses, and there's an ongoing concern as to the security and retention of those assets and whether they will be misappropriated or transferred. Ultimately, even where a case doesn't strike that, it's apparent on the face of the record why this was entered as a separate and final judgment, but judicial economy also warrants addressing this issue now. It's been briefed by the parties. Amici have weighed in. We are here. And Edward Stempniewicz has represented repeatedly that any adverse decision on this issue will be appealed. So a remand for further findings that does nothing other than to reiterate what has been incorporated by reference serves no purpose other than to bring the parties back here in short order. Turning to the issue of the trust, Section 105 of our trust code is clear that the requirements for creating a trust are mandatory, and those requirements are set forth in Section 402, and it requires that a settlor possess the requisite capacity and intention. It's practically speaking impossible for a third party to possess that capacity and intention on behalf of a settlor, and that same principle was discussed in the case of Phillip versus Till, a Texas appeals court case, which not controlling, but instructive. The statute.
Can I ask, I found the amicus brief sort of very thoughtful on this point, though. If the power of attorney expressly provides for the creation of a trust, isn't that clear enough indication of what this, isn't that enough? I mean, it's indirect, but it's express And we've got a lot of amicus who are very frightened if this power isn't allowed. They've got all kinds of issues out there. So why shouldn't we adopt that rule?
Well, Your Honor, I think this is a question of statutory construction. So the fact that the legislature took great pains in adopting the Uniform Trust Code in conjunction with our probate code addresses this, whether or not certain interests.
It's silent. It's silent on it, isn't it? It doesn't address the issue. It doesn't address the issue, right? Either way.
I think the silence does address the issue. The fact that the section 602 references the one instance where an agent under written power of attorney can interact and what is required to interact with a trust, and that there's no comparable authority in section 402 that cannot be read in. It's presumed to have been omitted by the legislature intentionally. And to the point that Amici raises, that this would needlessly create an ongoing requirement for conservatorships, the probate code adequately addresses that. Chapter 190B, section 5-408 provides a mechanism to authorize the creation of trusts without the appointment of a conservator through a single transaction petition or protective arrangement. There's no requirement of finding of incapacity, just that the security and needs of the protected person will be adequately met. So there are mechanisms to fill this gap where the settlor, for one reason or another, is not capable of exercising.
Section 407 does that as well and gives the court the power to address that issue, doesn't it?
Correct, Your Honor. And I would suggest that the omission of power to create by power of attorney is intentional.
Well, let me stop you there. I'm sorry to interrupt, Justice Lloyd, but you're suggesting that the omission is intentional. And your brother suggested that the failure of the legislature to not do what the other states did in amending 602, that we can infer that that's intentional also. Following up on Justice Lowy's question, how do we know that this is intentional in both instances? And do you agree on section 602 that that was intentional?
I'm sorry,
Sorry, I shouldn't have interrupted you, Judge Lowy. You go ahead.
No, not at all. I think it's a really important question. If you don't mind, Ms. Stafford, the argument is that, and Justice Kafka made the same point as well. All right, well, 602 lays out what we need to deal with when we're dealing with distribution revocation, for instance. But we have silence under 402 and 401, but you actually have power of an attorney document that allows for the creation of the trust. Going back to Justice Seifer's question, which way does the silence cut?
I think the Town of Canton versus Commissioner 455 Mass 783 addresses that, where the legislature employs language in one section intentionally, but not another. That omission in 402 is presumed to have been intentional. And reading that plain language of the statute on its face, it is requisite intent and capacity personal to the settlor, and not something that suggests that it can in any way be delegated to carry out by a third party. But to the extent that this court disagrees and is inclined to agree with Amici that it can be delegated, the only way to effectively delegate it is via express language. That's the only way in a power of attorney, which is required to be strictly construed, to actually delegate and express a clear intention to create a trust via a third party. And a number of cases outside of our jurisdiction have addressed this question in the context of the Uniform Trust Code and similar statutes, all reaching the same conclusion, that the only way to express that clear intent for something that is a separate and distinct transaction historically considered personal and non-delegable is to have it explicitly spelled out in the power of attorney. And the power of attorney.
Stafford, I'm sorry to interrupt you, but there's an issue that you haven't addressed yet that Mr. Tanner raised on behalf of the defendants. And it's a really simple, straightforward argument, which is put aside the power of attorney. What we have here is the defendant's mother isn't really able necessarily to get around and get down to the bank anymore. And what she's doing is she's just authorizing him to be her agent because she wants to change the trust, because now that she's moved to Massachusetts and the circumstances have changed, she's not comfortable with the will and the trust as it is. And why do we even have to look at the power of attorney or look at the trust language? He's just an agent.
Well, Your Honor, I think Record Appendix page 70, which is the signature page of the trust, addresses this issue clearly and disposes of it. The signature page states that Edward is signing explicitly under power of attorney for Lubov as settlor and as co-trustee. It does not state that he is signing pursuant to verbal authorization. Because this document is notarized, Chapter 222, Section 15 would have required the notary to take that direction from Lubov and to have mentioned that it was a verbal instruction to sign on her behalf in the acknowledgement clause. And that is not mentioned on this signature page. It's very clearly signed under power of attorney, which is also what his sworn statements indicate. That then turns to the power of attorney to determine on its four corners whether or not that power is encompassed. There's no contention that this is an unclear or ambiguous power of attorney. The only powers that discuss trusts are paragraph 7 and paragraph 8. Paragraph 7 is a section that allows the attorney, in fact, to accept or refuse assets that Lubov may be able to receive as a beneficiary from any number of sources: estates, conservatorships, escrows, and trusts. And strictly construing that, he's authorized to receive distributions or refuse them, but not to create a new document that is dispositive in nature in the first instance, or to exercise her intention to do so. And the interpretation offered by Edward is that a plenary or broad grant, the phrase all matters, should be enough. That has substantial implication in terms of harm. These are documents that are used beyond the supervision and purview of the courts. If a conservator cannot wield the power to create an estate plan or a trust without court authority, it stands to reason that a plenary grant of power and a power of attorney is not sufficient to put the principal on notice that they have given this power, that they are knowingly, voluntarily giving this power, and that they appreciate the nature, effect, and consequence of this action. That's where the explicit grant comes in, and that is also indicative of their intent as required by Section 402. The all matters interpretation advanced by Edward is not consistent with the balance of the power of attorney. The second trust power in paragraph 8 deals with funding.
Counsel, can I stop you on that last statement, which was, you said something to the effect of the express language in the power of attorney is indicative of intent, right? And I'm wondering why we can't interpret 402's requirement that the settlor indicates an intention to create the trust, as the amici suggest, that if the power of attorney had expressly stated, and you, attorney, in fact, can create a trust to the extent you think it's in my best interest, why isn't that enough to satisfy 402's settlor's indication of an intention to create a trust? Because what you just said was that her indication of intention is embodied in the words of the power of attorney. And to me, if the power of attorney actually said, and I get your position that in this case it doesn't, but if it actually said, you, Mr. Power of Attorney, Mr. Attorney, in fact, can create a trust to the extent it's in my best interest, why is that enough to satisfy 402? Why does it have to be her going to the bank to do the trust if she's not able?
I would agree with Amici that if this court finds that it is something that can be delegated in weaving through the power of attorney statutes, which do not preclude that, and noting the silence in Section 402, I agree that in that instance, if this court believes it could be delegated, it does in fact need to be explicit. That is the only way to express the intent.
And I have a second question, which is, don't we have to send this back because there's an affidavit from Edward saying, I put stuff in there too. It's not all just the settlor, it's my stuff too. And why isn't that enough? There's no prior statement that's directly in conflict like the cases you cite. This is The prior statements say, yeah, Lubov's stuff is in there. But now he's coming forward that it's an actual issue on summary judgment saying, hey, I got stuff in there too. Why isn't that enough?
I would say in this case, Your Honor, a couple of reasons. The first is it wasn't an isolated statement. There were numerous sworn statements.
Yeah, but they're all about her assets being in the trust. They're
Because
not saying only her assets are in the trust or exclusively her assets are in the trust. Yeah, her assets are in this trust. And now he's saying in response to summary judgment, yeah, her assets are in there, but there's also my stuff.
at the point in time that this statement is being made, it's important to remember the factual background of the case, that at all points in time, Mr. Stempniewicz was serving as a fiduciary, either under the power of attorney or the trust. This is a self-serving statement. He's trying to paper over and create a contradiction.
Self-serving, right? I mean, that just doesn't get you here nor there, right? I mean, he's now put it at issue. And on summary judgment, the judge doesn't get to make credibility calls saying, he only gets to do that, or he or she only gets to do that if there's a direct conflict. And what I'm suggesting to you is that I've looked at the pages in the record appendix that you cite, and I don't see that direct conflict.
I would respectfully disagree. I think there is a direct conflict. That the conversations, that sworn statements from Mr. Stempniewicz throughout the entire case was that this was a trust created for Lubov's assets for probate avoidance. Only when faced with summary judgment did he claim through a vague conclusory sentence that he contributed assets. There's no mention of what he contributed or when. There are no documents produced. This is all information that was within his control. And the summary judgment standard requires that he articulate more than just a general vague allegation, particularly when it's contradicting his prior statements. There's not even any explanation in his affidavits as to why this information wasn't included. Just a single sentence that is self-serving in an effort to drum up a dispute of fact.
Thank you.
And Your Honor, I suppose what I would like to close with is that the suggestion that there's no harm in allowing someone to rely on a broad general grant is inaccurate. This is a document that is used outside of court supervision. If it's prone and ripe for abuse, as this case indicates. And the absence of an explicit intention, if this is a delegable power, the absence of an explicit statement is problematic. It does not confirm the intention requirements under Section 402. And it also doesn't put any person signing a power of attorney on notice that they're giving someone this very important and special power, and that they understand the nature and consequence of what that means to have conveyed the power to create a trust, an instrument which can divest them of ownership of their assets and impact disposition not only during their lifetime, but after their death. And in this case, the instrument was used to do so in a way that was inconsistent with Lubov's prior estate plans.